I got court papers in the mail. I'm freaking out.
Court papers? What's going on?
I haven't paid my mortgage in like 6 months. I think I'm getting foreclosed on. What the heck am I supposed to do?
Do you want to keep the home?
Yes. I just had a situation arise that caused me to fall behind, but I can make payments again now.
It sounds like you should ask the bank for a loan modification. But before you do that, there is something far more important to get done.
What?
You need to file an answer to the foreclosure complaint.
File an answer? What's that mean?
You get 28 days after getting a complaint to file an answer to the complaint. It's your response to what they are saying you did wrong. Attached to the complaint should have been a summons which explains this 28 days.
Yeah, I saw something about that, but filing an answer sounds complicated. What if I just do nothing?
Then the bank will get a default judgment against you and the case could end very quickly. If you don't file an answer within 28 days, you could lose your chance to argue about any of this in court. If you don't file an answer, the court will assume you agree with everything in the complaint and boom, your case will end quick.
But how do I file an answer? I don't even know what that word, answer, means. I'm not a lawyer and Lord knows I can't afford one.
Let me walk you through it. Find the first page of the complaint. It's the page that lists who the plaintiff is and who the defendants are, and it probably says complaint somewhere near the top on the right-hand side.
Okay, I found that page.
All that stuff at the top, including the name of the court and the case number and the names, all that is called the caption. Write all that stuff down just like they wrote it, but where they wrote the word complaint, you write the word answer.
Okay, I've copied the caption and written answer where they wrote complaint. What next?
Now there are a bunch of numbered paragraphs. They talk about stuff the bank did, and then they talk about stuff you did, like not pay for 5 months. You need to respond to the allegations in each paragraph. Either admit what they are saying is true, deny what they are saying is true, or, if you don't know if it's true or not, say, I deny that's true for lack of knowledge.
Okay. Well, in the first paragraph they say the bank is the owner of a note and a mortgage. I should probably admit that is true, right?
Do you know for sure that that is true?
I don't know, not really.
Don't just assume something is true just because you think it probably is true. If you are not 100% sure something is true, don't admit it, just say you deny that paragraph for lack of knowledge.
Okay. I've gone through all the paragraphs. In paragraph 4 they say that I have an interest in the home and that I owe them a bunch of money. I still live in the home, so I guess I should admit I have an interest in the home, and the amount they say I owe sounds about right, but I'm not sure they've credited me for all of my payments.
Okay, here's what you should write next on your answer. You should write, defendant specifically admits having an interest in the real estate as alleged in paragraph 4 of the complaint. But defendant denies the remainder of the allegations in that paragraph.
Okay, got it.
Next, write down your responses to the rest of the paragraphs. For example, if you think paragraphs 2, 6, and 10 are definitely not true, but you aren't sure about the rest of them, then write, defendant denies paragraphs 2, 6, and 10 of the complaint and denies for lack of knowledge the allegations in the remaining paragraphs of the complaint.
Okay, I have now given a response to each paragraph in the complaint. Is there anything else I need to do?
Yes. Next, you should write a list of your defenses.
How do I do that?
Just write, the defendant raises the following defenses. 1. The defendant has paid in part or in whole the amount claimed due and owing. 2. The plaintiff is not the real party in interest. 3. The plaintiff has failed to join a necessary party. 4. Plaintiff has failed to service this loan as required by law. 5. Plaintiff failed to provide defendant with an acceleration notice. 6. Plaintiff's claims are barred by equity.
What the heck does all that mean?
Those are some common defenses that may apply to your case.
Are we almost done?
Yes, let's wrap it up. Next, you need to sign your name, and below that write your name and address and phone number and email.
Okay, is that all?
No, one more thing. When you file something in court, you always need to send a copy to the other side or the other side's attorney if they have an attorney.
Okay, well, I'm fairly certain the bank has an attorney. Where can I find that info?
The name and address of the plaintiff's attorney can be found near the end of the complaint. It also might be on the summons that came with the complaint.
Okay, I found it. The plaintiff's attorney's name is Bob Burns. He lives at 123 Main Street, in Springfield.
Okay, here is what you do. After your signature and address, and all that, write in capital letters the word Certificate of Service.
Certificate of Service?
That's right. The Certificate of Service section is where you tell the court that you mailed a copy of your answer to the plaintiff's attorney. So if you will be able to mail a copy to the plaintiff's attorney on July 4, 2011, just write, "I mailed a copy of this to the plaintiff's attorney, Bob Burns, at 123 Main Street, Springfield, on the date of July 4, 2011. Then sign your name again.
Okay. So I need to make a copy of this and mail it to Bob Burns, right?
Yes, here is what you do. Make 2 sets of copies. Mail 1 set to Bob Burns. Then take the original answer and the other set of copies to the clerk's office of the courthouse. Hand them to the clerk. The clerk will keep the original and time-stamp the copy and give it back to you. That is your proof that you filed it.
Okay, so I mail a copy to Bob Burns, then I take the original and another copy to the courthouse?
That's right. And you need to do that before 28 days pass from the day you got the complaint.
Yeah, I get the 28-day thing. Okay, so I file the answer, then what is next?
Then there is a period of time called discovery when you can ask the bank for a copy of your loan file. And you can ask them to answer questions under oath.
Maybe I'll ask you about that later.
Yeah. At any rate, the bank should not get a default judgment if you file that answer, and that alone can buy a few months of breathing room. In the meantime, contact your bank or whoever is servicing the loan, and see if they are willing to enter a loan modification with you.
Should I call them first, then file an answer?
No. File that answer first. Then call them. When they see you are putting up a fight, they may be more encouraged to work with you on a plan that will allow you to keep your home.
Okay, so I need to fight this thing in court, and at the same time try to work something out with the lender.
That's right. It's a 2-prong approach. And be persistent. Especially with these big national banks, be persistent in seeking that loan modification. Send in what they ask for. If they want your pay stubs, send those in. Make copies of what you send in and send the documents by certified mail so you have a record of what you sent in and when they got it.
Okay, I will keep pestering them.
Good luck.